Hello there. I am sure you have heard of media misinformation regarding the Don't Say Gay bill in Florida, which is actually called the Parental Rights and Education Bill. So I'm going to do you guys a solid and actually read to you the bill. So please feel free to share this video around because I know it's not going to pop up on anyone's For You page. And make sure that you tag people who have been spreading misinformation. But I'm sure some of you aren't going to stick around to hear the whole entire thing, so I'm going to give you the highlights. This bill does not ban the word gay, and it does not ban gay people. It doesn't make people not exist and all the other hysterical things that people have said about it. What this bill actually does is it stops teachers and administrators from conspiring against parents to hide important information and medical records that would be important for their child's well-being. Unless there's reason to suspect that that parent would be abusive or abandon them in the event that they found out that information. It does bar classroom instruction based off of sexual orientation and gender identity for grades kindergarten through 3, or unless it's deemed inappropriate for their age. Now, unless you have good reason to teach a 6-year-old gender identity behind their parents' back, I don't know why you would oppose this bill. And for all of you saying, well, there's no reason to make such a bill. There are, you just not have been paying attention. That's a video for another day. Let's jump into the bill.
It enacted by the legislature of the state of Florida. Section 1, paragraph C is added to the subsection 8 of section 1001.42 Florida statutes to read 1001.42 powers of the duties of the district of the board. The district school board acting as a board shall exercise all powers and perform all duties listed below. Student welfare. In accordance with the rights of the parents enumerated in SS 1002.20 and 1014.04, adopt procedures for notifying a student's parent if there is a change in the student's services or monitoring related to the student's mental, emotional, or physical health or well-being, and the school's ability to provide a safe and supportive learning environment for a student. The procedures must reinforce the fundamental right of parents to make decisions regarding the upbringing and control of their children by requiring school district personnel to encourage a student to discuss issues relating to his or her well-being with his or her parent, or facilitate discussion of the issue with the parent. The procedures may not prohibit parents from accessing any of their students' education or health records created, maintained, or used by the school district as required by S 1002.22. A school district may not adopt procedures or student support forms that prohibit a school district personnel from notifying a parent about his or her student's mental, emotional, or physical health or well-being, or charge in related services or monitoring, or that encourage or have effect of encouraging a student to withhold from a parent such information. School district personnel may not discourage or prohibit parental notification of and involvement in critical decisions affecting a student's mental, emotional, or physical health or well-being. This subparagraph does not prohibit a school district from adopting procedures that permit school personnel to withhold such information from a parent if reasonably prudent person would believe that disclosure would result in abuse, abandonment, or neglect, as those terms are defined in S.39.01. Classroom instruction by school personnel or third parties on sexual orientation or gender identity may not occur in kindergarten through grade 3 or in a manner that is not age appropriate or developmentally appropriate for students in accordance with state standards. Student support services training developed or provided by a school district to school district personnel must adhere to student services guidelines, standards, and frameworks established by the Department of Education. At the beginning of the school year, each school district shall notify parents of each healthcare service offered at their student school and the option to withhold consent or decline any specific service. Parental consent to healthcare service does not waive the parent's right to access his or her student's educational or health records or to be notified about a change in his or her student's services or monitoring as provided by this paragraph. Before administering a student's well-being questionnaire or health screening form to a student in kindergarten through 3rd grade, the school district must provide the questionnaire or health screening form to the parents to obtain permission of the parent. Each school district shall adopt procedures for a parent to notify the principal or his or her designee regarding concerns under this paragraph at his or her student's school, and the process for resolving those concerns within a 7-day calendar days after notification by the parent. At a minimum, the procedures must require that within 30 days after notification by the parent that the concern remains unresolved, the school district must either resolve the concern or provide a statement of the reasons for not resolving the concern. If the concern is not resolved by the school district, a parent may request the Commissioner of Education to appoint a special magistrate who is a member of the Florida Bar in good standing and who has at least 5 years' experience in administrative law. The special magistrate shall determine facts relating to the dispute over the school district procedure or practice, consider information provided by the school district, and render a recommended decision for resolution to the State Board of Education within 30 days after receipt of the request by the parent. The School Board of Education must approve, reject, or recommend decision at the next day regularly scheduled meeting that is more than 7 calendar days and no more than 30 days after the date the recommended decision is transmitted. The cost of the special magistrate shall be borne by the school district. State Board of Education shall adopt rules, including forms necessary to implement this subparagraph. Bring an action against the school district to obtain a declaratory judgment that the school district procedure or practice violates this paragraph and seek injunctive relief. A court may award damages and shall reasonable attorney fees and court costs to the parent who receives declaratory or injunctive relief. Each school district shall adopt policies to notify parents of the procedures required required under the subparagraph. Nothing contained in the subparagraph shall be constructed to abridge or alter rights of action or remedies in equity already existing under the common law or general law. Section 2, by June 30, 2023, the Department of Education shall review and update as necessary school counseling frameworks and standards, educator practices and professional conduct principles, and any other student services personnel guidelines, standards, or frameworks in accordance with requirements of this act. This act shall take effect July 1st, 2022.